In this podcast, we pick up from the last one, where we discussed using promissory estoppel as a shield and as a blunt sword. And in this case, we talk about, can it be used as a sharp sword? In Australia, promissory estoppel can be used as a sharp sword, which we'll see in Waltons stores. In Waltons stores, the facts were that Mayer was in negotiations with Waltons stores to lease a premises, which were to be demolished and rebuilt to Waltons' specifications. The parties instructed their solicitors to prepare the documents, and Waltons stores solicitors told Mayer's solicitors that, quote, "We believe approval will be forthcoming. Let you know tomorrow if any amendment is not agreed to," end quote. Mayer submitted the contract, which was sent to Waltons stores by way of exchange. And before receiving Waltons' response, Mayer commenced demolition. He believed that the exchange would take place shortly, and he knew that if Waltons' timetables were to be met, then he had to start the work. 2 months later, when Mayer was well into the work, Waltons' store's solicitor informed him that Waltons did not intend to proceed. Mayer argued that Waltons was stopped from denying that a concluded contract existed. So the issue here is promissory estoppel an independent cause of action? And it would be here because there's no contract between Mayer and Waltons stores, and yet Mayer is suing Waltons stores on the basis of a promise that Waltons stores made. The ratio is promissory estoppel can found a cause of action where unconscionability is found. In this case, the High Court found that Waltons' failure to communicate constituted an undertaking to enter into the lease, and that Waltons was aware of the reliance that Mayer had placed on that undertaking. The problem, they acknowledged, was that Mayer's claim for breach of undertaking is that the undertaking to enter into a lease was given without consideration. Waltons simply told him that it would enter into a lease with him, or their solicitors told him. If you enforce that promise, you have to deploy promissory estoppel as a sharp sword. And they were reluctant to do that. They acknowledged that there's been a lot of reluctance to do that. Nobody wants promissory estoppel to become a vehicle to positively enforce a promise by a party that it would do something in the future where there's no existing contract. The court also acknowledged in Denning's assertion in Coombe that estoppel can be part of a cause of action, but it cannot be the cause in itself. In this case, the court is looking at taking promissory estoppel one step further. It is looking at using the doctrine to enforce a promise in the absence of any pre-existing relationship. It is a non-contractual promise. Yes, the representee relied on the promise to his detriment, but there was no contract, and the promise was gratuitous. So the court here turned to the principle of unconscionability. It said that if you look at all these cases, the common thread between all of them is that there is unconscionability. They said equity comes to the relief of the plaintiff on the ground that it would be unconscionable conduct on the part of the other party. Now, failure to fulfill a promise by itself is not unconscionable. You can make a promise and not carry through. Mere reliance on a promise, so if the promisor just changes his mind and the promisee has relied on that promise to his detriment, that also does not amount to unconscionable conduct. So making a promise and breaking it is not unconscionable. Making a promise, breaking it, and having someone rely on it is not unconscionable conduct. You have to have something more. And that something more is the encouragement by the party who made the promise. That party who made the promise is encouraging the party who's relying on the promise that to keep going, because a contract will come into existence or a promise will be enforced. And the other party relies on that assumption to his detriment. And the first party knows about it. So here, they said the appellant was not entitled to stand in silence when it must have known that the respondents were proceeding on the assumption that they had a completed agreement. The appellant was under a duty to communicate with the respondents within a reasonable time, and certainly when it learned that the demolition was proceeding. Walton Stores wasn't entitled to do nothing. It was unconscionable for it, knowing the respondents were exposing themselves to detriment by acting on the basis of a false assumption, to adopt a course of inaction. And that course of inaction encouraged them in the course that they had adopted. Mason and Wilson adopted the language of promissory estoppel and said that the appellant is stopped from retreating from its implied promise to complete the agreement. And the Brennan judgment said that the minimum requirements to give rise to unconscionable conduct was the inclusion of an assumption or an expectation as to a legal relationship between the promisee and the promissor. The Walton Stores doctrine was recently distinguished in Canada. So Walton Stores is from Australia, and in Canada we had a case at the BC Court of Appeal. It was not, and where promissory estoppel as a sharp sword was argued. It was not rejected as being inconsistent with Canadian law. Now, in Walton Stores, the basis for that decision was the action of the lawyer, of the company's lawyer, in not telling the owner of the company that Walton Stores had had second thoughts, and therefore leading the owner to reasonably believe that the lease had been accepted, that they would enter into a lease agreement. And the remedy that was necessary to protect the owner's reliance was a money judgment for the costs that were incurred. Walton Stores illustrates two important concepts to protect reliance. The party who has relied must be able to show that the other party did something or said something on which it reasonably relied, and there was actual reliance as a matter of fact. So if these two facts are proven, there is a basis for protecting the party who has relied. Now, let's talk about this case. This case involves a failed relationship. M had promised A that he'd pay the balance outstanding on her mortgage in her home in England if she came to live with him in Canada, with a view to marriage. In reliance on that promise, she left her job and moved to Canada. They had a stormy relationship, partly due to the fact that M was not paying the balance of her mortgage off, but he did loan her $100,000 on a promissory note, and she applied those funds directly to her mortgage. About a week later, M kicked A out of his house. A hadn't been able to find permanent employment anywhere in England or in Vancouver. And the issue here is, should the promise on which A relied to her detriment be enforced? Can the doctrine of promissory estoppel be extended to a situation where there is detrimental reliance on a promise that is intended to bind its maker and be acted upon by the promisee to the knowledge of the promissor? If you look at it that way, without the context, you would probably say yes. The trial judgment said the plaintiff did promise to pay off the mortgage, and the defendant did rely on that promise to her detriment, but the defendant failed to establish the existence of a legal relationship between the parties at the time the promise was made, and so the doctrine of promissory estoppel doesn't apply. And the ratio is that it's unclear, but we may be able to say that the doctrine of promissory estoppel still can't be used as a sword where the parties fail to establish an existing legal relationship. But could we say that it may be used where there is no existing relationship, but the promisee relied on the promise to his detriment, where the parties were about to enter into a legal relationship? Well, in Waltons, the court said that it was seen as something more would be required if the court was to find unconscionable conduct in the failure to fulfill a voluntary promise. And that something more was the promisee's reasonable reliance, reasonable assumption that an agreement had been reached. Now, the law is slowly moving towards a more generous approach to promissory estoppel, And the court wouldn't comment specifically on whether you need an existing legal relationship to apply the doctrine of promissory estoppel as a sword in Canada. But it did say that the parties here, in this case, were not intending on entering into any legal relationship. The promise was made in the context of a relationship both of them thought would be permanent and would result in marriage, not that it would be fulfilled to compensate A for the detriment that she would suffer. So a romantic relationship and marriage, entering into a marriage, is not the same type of legal relationship we're talking about when we enter into a commercial relationship.